Rise. Court of Appeals Division 1 is now in session.
Thank you. Please be seated. Good morning. This is the time set for oral argument in our cause number CV130630, Snyder versus Banner Health et al. Counsel, as you probably know, we are recording today's proceedings, both audio and video recordings. So when you step to the podium, please state your name and the client that you represent. Each side will have 20 minutes for argument, and Mr. Seplow, you're responsible for watching the clock and reserving any time for rebuttal that you might desire. And Appellee's counsel, I assume, will divide your 20 minutes however you see fit. We have read the briefs. We've conferenced the case prior to argument. And with those preliminaries, Mr. Seplow, you may proceed.
Thank you. Good morning, Your Honors. My name is Philip Seplow, and I represent the appellant, Patricia Snyder. As I was driving down here today, I thought about all the people who daily or weekly or monthly fill out medical powers of attorney, and there must be thousands of them. And I think the importance of this case is that it appears as if the trial court might have, with a movement of a pen or a decree from the bench, voided the effect of these power of attorneys, even though it's fairly well contained, the duty is fairly well contained in the statute. In this particular case, Mrs. Snyder, the wife of the patient, John Snyder, was having problems with Banner Hospital. The hospital knew that Mr. Snyder had filled out a power of attorney back in October of March 29th of 2009, and when he was taken into the hospital on October 23rd, they had him, quote, fill out a medical power of attorney, but it really wasn't filled out because they said it was verbal. But the point is, the statute says that the surrogate, and in this case that's Mrs. Snyder, when the husband or the loved one or whoever is the person who signed the power of attorney, assigning the surrogation over to the other person, is not really in a position to take care of themselves, that not only does the hospital have a duty to listen to the surrogate, but it also, if you read the second part of the statute, they have a duty to volunteer information. And in the trial court, it appears as if the trial court just basically ignored that duty. There are a lot of other counts here, and those other counts were dismissed in the second amended complaint and the third amended complaint, as the court knows from reading the briefs. But if you look at the second and the third amended complaint, they almost read like novels. It's beyond notice pleading. And if it's true that the plaintiff, or in this case the appellate, can assume that what she alleges is going to be taken as true for the most part, and they are verified complaints, there is really hardly any reason at all, if any, for the trial court to dismiss the rest of her issues. But I think what this case boils down to is, what is the effect of the medical power of attorney?
The only relevance of that is as to each cause of action alleged, and as you note in your brief, some of those don't require a legal duty. So
right.
The negligence-based claims, yes, the question would be, is there a duty? But there's no free-floating breach of statutory duty claim in your complaint, and so duty only is relevant as it relates to each of the claims.
Well, that's true. There is no specific complaint for breach of the statutory duty in the third amended complaint or the second amended complaint. As a matter of fact, I think the judge in the trial court said there wouldn't be a duty anyway, that there's no cause of action for that. But the duty that is owed to Mrs. Snyder from the statute, I believe, is a foundation for some of the nasty things that Banner did to her. For instance, not volunteering information. For instance, taking her away from her husband when she came to pick him up. I think the court realizes that he was taken to the hospital on October 23rd. The wife didn't even know. He gets there. By October 25th, Dr. Butler writes a release. So Mrs. Snyder comes down, she's got a wheelchair, she's going to take him out, and they basically physically assault her in disregard of the release written by Dr. Butler, and they take her back, take him back to the hospital. She tries to see him. And if they do, in fact, have this duty that Your Honor has talked about, it certainly travels, for lack of a better word, travels to some of these things that Banner was avoiding or purposefully not allowing the wife to participate in. For instance, Respirol. He's not supposed to take Respirol. She's trying to tell them, don't give him Respirol. It's in the VA. And they still give him Respirol. She tries to talk to him on the phone. They rip the phone out. He's crying. There was a witness to that. He's crying and he wants to talk to his wife. When he's released, it's interesting because Dr. Gull and Banner write this, memo to the Adult Protective Services saying that he's been suffered abuse. By October 27th, Adult Protective Services, there's no abuse. Matter of fact, he wants to see the wife. They continue with that course of action to the VA, to the Attorney General, and I think, I'm not 100% sure, back to APS. It's just frightening what they did, and I think it flies right in the face of that statute, which says not only does the surrogate stand in the position of the patient, but the hospital or the healthcare provider has the obligation to volunteer the information. In regard to all the other counts, the intentional infliction of emotional distress.
Can I interrupt you there just
Sure.
a little bit? Because you're mentioning the statutory duty and then you went to the other counts. There is no count for a statutory violation.
There's no count for that, yes.
Okay.
I've admitted that, yes.
Okay, I was confused because it seems like a lot of the focus, what you've given us so far, talks about a statutory violation, and I read the pleadings differently.
Okay. Well, the focus is on that because had the hospital and Dr. Goel not thumbed their nose, so to speak, and I think that's what they did, to the power of attorney, then some of these other counts wouldn't even be necessary because the counts wouldn't exist because the hospital and Dr. Goel would have followed through with what the statute says. And by not following through what the statute says, that's how some of these other counts come into effect, because they deny her access to her husband, they deny her information. When he was released, he was 10 pounds lighter than when he went in, and he was pretty light when he went in. He was on delirium. They never warned, and I realize this is not a medical malpractice and we're not suing for medical malpractice. They never warned Mrs. Snyder of all the things that would occur or may have occurred when he was released. The fact of the matter is they kept him there when Medicare said, oh, we don't have money for you anymore. They released him on November 4th.
But we take this case
Yes.
solely based on the pleadings, right? I mean, and there were some things offered to the Superior Court that were not in the pleadings, but this motion was not, these motions were not converted into a 56. We're talking Rule 12.
Right.
Across the board.
Right.
Okay.
And that was the other part, but I think the court understands that this was not a summary judgment motion. And if one looks at the third amended complaint, got to find it. It's very fact specific as to a lot of the facts that I have described to the court today. And I just want to make sure I have the third amended complaint in my hand. I do. And so, obviously, you don't need a duty for the intentional infliction of emotional distress. So that's count one. And I'll go to count two. There's a negligent infliction of emotional distress, which I realize is a little troublesome, but when you think about the most famous negligent infliction of emotional distress case on the books, it's where the mother's in the kitchen and she's watching her children playing in the cul-de-sac, and a car comes and hits the children in the cul-de-sac, and there's the issue of zone and danger. In this particular case, she has her husband in a wheelchair, and they forcibly take her husband out of her hands, wheel him back, and forbid her to come and threaten to arrest her. And that certainly flies in face of the statute and of the medical power of attorney. And that's why the medical power of attorney, Your Honor, is so important, because everything they do flies in the face of that. And just because there's not a specific count on that doesn't mean it can be ignored. If there aren't any more questions, I could reserve.
No.
Okay, thank you.
Good morning, Your Honors. Eileen Gilbride for Dr. Gohl. I'm going to split the time with Ms. Dean if I need 10 minutes. If I don't, she can have the rest of it. I'd like to briefly touch on two issues with respect to Dr. Gohl, and the first is this power of attorney issue. Plaintiff's counsel basically just made my point, which is they did not sue for a breach of the power of attorney statute. So there is no breach of statute claim. She made a claim for negligent infliction and intentional infliction and alleged that the failure to abide by this power of attorney constituted negligent and intentional infliction. This factual allegation doesn't state a claim for either negligent or intentional infliction. Negligent infliction, as the court knows, Dr. Gohl had to do something to place plaintiff into the zone of danger where she either suffered immediate physical harm by watching an injury to her husband, or was herself placed in the zone of danger, in immediate physical harm. And the failure to follow a power of attorney just doesn't fit that rubric. She also seemed to suggest that she witnessed defendants negligently treating her husband, or that they negligently discharged him without telling her of his current state of mind. That just doesn't fit into the whole zone of danger rubric either. Not only that, but if she was going to make that kind of a claim, she would need an expert to say that defendants were negligently treating her husband, and therefore witnessing that put her in the zone of danger, which it didn't anyway, but plaintiff filed 4 different complaints and never came forward with an expert affidavit for that. On the intentional infliction claim, that was similarly defective. She didn't allege anything that Dr. Gohl did that was atrocious or utterly intolerable in a civilized community. Again, the allegation that they ignored the power of attorney, that's just not atrocious or utterly intolerable in a civilized community. And of course, the court makes that decision in the first instance as to whether the alleged facts rise to that level.
Wasn't that a claim where there was a difference in the allegations between your client and Banner? In fact, at oral argument, Judge Talamonte, I believe it's Judge Talamonte and not Judge Padish at that hearing, but whichever one focused on that and said, where in the complaint do you allege any conduct by Dr. Gohl? Mr. Sepolo said, I'll have to get back with you, and then the court found
there wasn't any.
No basis. So most of these claims, it seems like the two defendants are in similar footing, but that was one where there was a distinction, I believe, that the court found.
I know that the court found no alleged facts that were utterly atrocious for Dr. Gohl.
Can I tell you the one claim that,
please.
A claim that gives me some pause in terms of a Rule 12b-6 or 12c standard, and that's defamation.
Right.
I know that both defendants have a number of defenses, and maybe at summary judgment those could be litigated, but the statute of limitations claims, it seems like the complaint is minimally adequate to get past that on a 12b-6 or 12c standard. The immunity issue, again, without looking at anything beyond the pleadings, it's difficult for me to say that should or shouldn't be dismissed at this point. So talk to me about that, if you would.
The only 2 statements that plaintiff alleged Dr. Gohl made were, 1, there was no food or running water in the home, and 2, he wrote in the chart, the home is unsafe. Those two statements are just not defamatory as to the plaintiff. They don't put her in a position of harming her reputation or, lowering the community's estimation of her reputation. So, A, those two statements, the ones that they claim he made in the chart, are just not defamatory, A. B, they didn't allege that he made those statements with malice, which they need to allege in the complaint. And that means ill will or excessive publication. Certainly there was no excessive publication. He made those statements in the chart, if he made them, and that's not excessive. Or to the VA doctor, where they were trying to get Mr. Snyder to be transferred over to the VA hospital. That's the common interest privilege, which says that when people have a reasonable belief that a statement is in the common interest or in the interest of a third person, that's conditionally privileged. And they haven't alleged that Dr. Gohl had any ulterior motive for making these statements in the chart.
But again, looking at under the standard we have to review it, we can't even look at the chart. I mean, that's not part of the pleadings. And so
right, but that's what she alleged. She alleged that he made these statements, one on the phone to the VA doctor, that the home had no running water or electricity. You don't need the chart at all. All you need is the allegations of the complaint. And to say, A, that there's no running water in the home, that's not defamatory to her. That doesn't injure her reputation, A. And B, it's conditionally privileged as someone, the VA doctor would have to know if Mr. Snyder was being transferred there, what was the situation, what caused him, to suffer these ills. And B, the statement that she alleged in the chart, that the home is unsafe. Again, not defamatory to the wife. It just says the home is unsafe. And so, that doesn't impinge her reputation. Even if it did, though, again, there's no allegation of malice that he would have said this for some ulterior, improper, ill will motive. And third, she didn't allege that she suffered damage to her reputation.
is the operative pleading for defamation the third amended complaint, or is it the
Second amended complaint. And you can see in there, it's page 8, where she alleges these are the two statements on which she's basing this claim against Dr. Gohl. So our defense on that is, A, they're not defamatory. B, even if they were, he has the conditional privilege under the restatement, section 595 and 596. And third, she didn't allege that her reputation was harmed as to them. So those are even if you throw out the statute of limitations, and I would disagree that the complaint is enough to get by, but we can agree to disagree on the statute of limitations issue. We don't need that. We have these other three defenses to that claim. Unless you have other questions, I'll turn it over to Ms. Dean.
No, I don't think so. Thank you.
Good morning. May it please the court, my name is Margaret Dean, and I'm here this morning on behalf of Banner Health. I'm happy to go through these various counts in any order or to address any issues you have. Otherwise, I probably would tend to start or be inclined to start with the intentional infliction of emotional distress claim, because that's the one that's unique as to Banner, and Ms. Gilbride has addressed these other ones. So starting with that claim, I believe really the key question is whether or not there was sufficient evidence of extreme or outrageous conduct, and that's a court determination. So it's
But when you say evidence, that's summary judgment standard. Here, it's whether it was sufficiently pled.
Yeah,
and that's where I have some difficulty.
Yeah, I appreciate that correction, because I actually misspoke. Looking at the complaint itself, the question is whether or not the complaint as pled could possibly satisfy the standard, and I believe it doesn't. The case law in Arizona is pretty clear about what extreme, outrageous, and atrocious conduct is, and under no interpretation of the facts as pled could any reasonable person conclude that that there was outrageous conduct such that would offend all notions of decency in the public.
Are we also dealing with the second amended complaint for intentional infliction, or is it the third?
It's in the third. I had to keep a matrix to keep these straight, but I'm pretty sure that one's in the third. As to that claim, as again, which is specific to Banner in this third amended complaint, I don't think there's any way to conclude that the allegations as pled could satisfy in any conceivable way that standard, and the court is required to make that determination and exercised its gatekeeping function in doing so. I would move next to the power of attorney issue, because I think that's one that the court has indicated may have raised some concern, and I would share in Ms. Gilbride's observation and point that there is no claim here, discrete claim for a breach of a duty arising under the power of attorney statute, and in fact the statute does not even create or recognize such a duty, so the court properly determined that that was not a basis upon which this case could go forward. Running through the remaining claims as to Banner Health, as to the negligent infliction, well, let me actually skip that and come back to the defamation claim, because that was another one that you indicated gave you some pause. And I would respectfully disagree that the statute of limitations defense is questionable. I actually think it's very clear, because that we know from the complaint itself, the date, and I think it is the third amended complaint as opposed to the second, perhaps both, but the date of the events in question are alleged in that complaint. October 23rd, 2009. We know for a fact this complaint wasn't filed until more than a year later. So as to the defamation claims, those are very clearly barred by the statute of limitations, and that is something that can be determined from the face of the complaint.
Isn't it a little more searching than that, though? Isn't it not when the events occurred, but when the statements were made and when, with the discovery rule overlay? In reading the complaint, it appears quite clear to me that all of these statements were made in connection with that hospitalization, which is the date. There were no statements made after the fact. I mean, they were all made. Writings as well?
They were all made in connection with that hospitalization on October 23rd.
Correct. But let me give you a hypo. Let's say it happened November 1. Things were written down that plaintiff didn't discover until 13 months later. Under your view, that's still time barred. Again, on a 12B
right.
context.
Right. Well, I guess I would preliminarily, the first thought that occurs to me is that there's no allegation of a delayed discovery of those comments. The complaint, I think, largely is based on oral statements made on. But as to the written statement, I don't believe there is any allegation of a delayed discovery. So I see your point, but I think that in the absence of some allegation that these were not discovered until a later time, you would have to assume from the complaint that that cause accrues as of the date of these events and as of the date that these statements are made or placed into the record, the written statements and the oral statements.
And again, recognizing we're in a really limited slice of this case in the Rule 12 context. With the intentional infliction, I know you've moved on to other things, but isn't it, one way it seems to read the complaint is that plaintiff is alleging she was denied access to her husband, denied the ability to participate in his medical treatment plan, and was threatened with arrest. Now, we're not here as a court or otherwise to divine the truth of the allegations, but your view is, as a matter of law, that cluster of facts is insufficient to show intentional infliction of emotional distress.
That's correct. And I outlined in the brief, I gave some examples of cases that I submit would be viewed subjectively, I suppose, by anyone as being much more extreme than that, and yet they did not meet that standard. So the trial court, I believe, was appropriately looking at what that standard is as evidenced by various cases in Arizona as to what we know constitutes outrageous conduct. And the facts of this case, as pled, don't come anywhere near that standard.
So what in the medical treatment context, let me ask you, what hypothetical would, if and again, based on those three allegations, you can't see your husband, can't participate in his medical care for a period of days, and we're going to arrest you. If that's not enough, isn't that just sort of saying that tort could never occur in the medical treatment
Well,
context?
maybe I'm not that creative, I guess, to conceive of a scenario that might meet that. I think it's one of those, honestly, I think it's one of those scenarios where you know it when you see it. But again, if I read the case law that sets forth what type of conduct constitutes this outrageous conduct, these facts, as pled, don't come close to that standard. And I can look at the I don't remember them offhand, but we can look at the brief. But there are examples of much more. I mean, you're trying to prioritize and I guess order events that apples and oranges. But I think in any event, this pleading doesn't have enough meat on it for the court to have determined that, yeah, this meets that gatekeep. I'll let this pass through the gate and say we'll go on, and because a jury could find that this is outrageous and extreme and violates all standards of decency in our community. I think the court got it right.
I think there's something in between a jury and Rule 12, and we've mentioned it a number of times, and you may have some very good fodder for a motion for summary judgment, but when I read the cases you've cited, none of those were in a Rule 12 context. And that gives me a bit of pause. Can we backtrack just a minute, because I want your reaction. There is an allegation in the third amended complaint under the defamation count, paragraph 46, saying the Snyders had no idea any of this was happening behind closed doors, and many of the false statements have recently been discovered. Again, in the context of Rule 12, is that enough to kick this to the summary judgment stage?
Well, if you're basing it on the issue of statute of limitations, I would concede that, but you still have these other issues, and one of them was touched upon by Ms. Kilbride, and that is this idea of conditional privilege. Can a statement that a physician or a hospital worker places into a medical record for the purposes of making medical treatment for the benefit of the patient constitute defamation? And are any of these statements, that's one question. The other question, of course, and I think the court got that right as well, is these don't even rise to the level of constituting a defamatory statement. They are simply
statements, in addition to those Ms. Kilbride outlined about her client, that were made as to banner over and above the no running water and
if you tell me again, Your Honor, which paragraph, I'd like to take a look at it.
I don't know. She was telling us that as to her client, I believe in the second amended complaint, those are the allegations as to Dr. Gold. But
yeah, the defamation claimed as to Banner are in the third amended complaint, and I think they're outlined on page 11. And there are things like the Carol Brown, who's a hospital employee, said wife is missing. Patient suffered abuse and neglect. These are not defamatory statements in and of themselves. They are reporting or documenting information that's provided to them. There's no indication of no allegation even of any malice or ill intent other than healthcare workers simply documenting information that has been provided to them. And I don't think there's any.
What about communications with the VA, which I think were outside of the actual medical records context? There were allegations, as I recalled it.
Yeah, again, on page 11 of the third amended complaint, the allegation is that there was a report faxed to the VA by Carol Brown, a Banner employee, which said no running water at their home and little food. And so if that's the statement that you might be referring to, that's clearly not defamatory. It's a reporting of information that's been provided. I don't know how that could be construed as a defamatory statement, something that brings into ill repute or questions the integrity of Mrs. Snyder. So I think the court, looking at these, and I have to make the point too, is that the trial judge gave the plaintiff 4 cracks at it here, and was very specific about what needed to be pled, and by the fourth time around, we should have had some, if these claims were viable, we should have been able to see in very clear terms that they were viable based on the pleadings, and that really never happened. And I think the court, if you read the court's rulings, determinations on these issues, that was clearly a frustration that we've asked. Plaintiff been given multiple opportunities to plead these claims and never did. And that's why I believe the court concluded, after reviewing each one, that they weren't sufficient to go forward based on the pleadings. So my time is almost up. If there's anything else, I'd be happy to address it.
No, thank you.
Thank you.
Rebuttal, Mr. Seflo?
Briefly, in regard to the defamation, on page 11 of the third amended complaint, there's a whole litany of things. And here's where I think the defamation smoking gun is. There may have been a privilege initially when Dr. Galel called Adult Protective Services and said, oh, we have an abusive wife. But when the report came back on October 27th that everything was fine, Dr. Galel continued his course of conduct in that respect.
And what do you mean specifically, and where is that pled? Because Ms. Gilbride said the only allegations against Dr. Gohl were that he wrote in the reports that there was no food or running water and the home is unsafe. So point me to where in your complaint there are specific allegations against him as to defamation.
Sure. Page 11, bottom of the page, G. The home is unsafe was noted by Dr. Galel in the medical record 24 hours prior to releasing Mr. Snyder. So he does it on the 23rd. The report is made on the 25th to the 27th, and then they release him because Medicare won't pay anymore. And
how is that statement defamatory as to your client?
Because my client is, traditionally runs the home. Her husband is a veteran who's not in the best of shape, and she is the person who takes care of her husband. She told the Banner people, she told Dr. Galel if she got the opportunity, Dr. Galel calls her at the end and says, we're releasing your husband. Doesn't tell her that he's gone through delirium, doesn't tell her that he's lost 10 pounds, doesn't tell her that he's dangerous. And that's Dr. Galel. And so, yes, Dr. Galel also tries to get the Attorney General involved. Again, initially I said the complaints read like a novel, but it's also still notice pleading, and then in the arguments and the presentation of arguments that lead up to today, other things were factored in there that Dr. Galel did.
Well, but we have to look at whether the well-pled allegations, not things that aren't in there, and the only things I'm seeing are G, as you noted, and H. As to him, is there anything else in the complaint that you can point me to as to Dr. Galel that?
Okay, that was the third amended complaint, right, Your Honor?
Correct.
I think also part of the argument that Ms. Snyder has while I'm looking through the second amended complaint is that Dr. Galel is in a supervisory position of people like Carol Brown and Kathy, I think it was Kathy Brown also, the people who were mistreating, I don't know any other way to say it.
President at the time. And where have you alleged that he has some sort of vicarious liability for hospital staff? Where is that alleged?
I don't know if it's specifically alleged. Let me see.
Counsel, with the defamation point, you're looking at the second amended complaint now?
Yes, Your Honor.
Which was dismissed without prejudice, right?
Right.
So, I mean, I'm happy to know what's in there, but that is not an operative pleading.
Yeah, the third amended complaint is the operative pleading for defamation.
Okay, well, all right. I was under the impression when there's an order dismissing Oh, I see what you're saying, though. Okay, I agree with that.
Your
Yeah.
client had an opportunity to reallege it and did, and
Right.
that's why I think Judge Downey was focusing on that
Okay,
aspect
that's
of the
fair
Third
enough.
Amendment complaint.
That's fair enough. In closing, I would say that although there is not a specific allegation of breach of the statutory duty, and I think it's clear that there's a statutory duty. If you read the statute, I don't see how anybody can say anything else but there's a statutory duty in regard to people who are the surrogates of holders, people who hold the medical power of attorney. Based upon the flagrant denial of those mandates or suggestions in the statute, everything that Dr. Golel did was certainly with malice. Everything that Banner Hospital did certainly was with malice. You can't call a woman down to the hospital to see your husband and then kick her out without seeing him, and that's what happened. And when learned counsel on the other side says that this doesn't rise to outrageous conduct, I don't know what else will. If there's any other questions, I'll answer them.
Thank you.
Thank you.
Thanks to all of you for your arguments. We will take this matter under advisement and issue a ruling in due course. At this time, the court stands adjourned.